The room was very still when I finished speaking. I could hear the ventilation system humming in the ceiling, steady, indifferent, while something permanent settled into the room below it. That is what I remember most from that moment. Not the faces, not the sound that came after, just that hum and the weight of what had been said. I want to tell you how I got there, but first I need to tell you who it was about. That is where I want to begin. Not with the case file, not with the denial letter, not with the man who signed his name to it, with her name. Because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. She was not a number to me. She never was. I said her name to myself the morning before the verdict. I say it to you now before I say anything else because she deserves that order. I have one request before I go further. Subscribe to this channel, not because I need the numbers, because Eleanor, the woman at the center of this case, deserves to have her story heard by more than the people who happened to be in that courtroom. Subscribe, then let me continue. On April 8, 2019, Dr. Reina Okafor submitted a prior authorization request to Caritas Health Partners for Eleanor Marsh's chemotherapy. Eleanor had been diagnosed with stage 2 ovarian cancer 5 days earlier. She was 72 years old. The authorization was reviewed, processed, and returned as a denial on April 14th, 6 days. 6 days to look at a 72-year-old woman's cancer diagnosis and decide that the treatment her doctor prescribed was not medically necessary. The denial letter arrived at Eleanor's house on April 17th. She told her daughter she read it standing at the end of the driveway, still in her slippers, because she had gone out to get the mail before she was fully dressed and she could not make herself go back inside while she was reading it. She stood there for 22 minutes. Her daughter timed it from the kitchen window. The man who signed the denial was Derek Voss. He was 44 years old and had worked as a senior claims adjudicator for Caritas Health Partners for 11 years. When he walked into my courtroom on September 14, 2021, he carried himself the way people do when they have decided what they are about to face is manageable. He sat at the defense table, folded his hands, and arranged his face into something neutral. I watched him the way I watch everyone, from above, from stillness, trying to understand who I was dealing with before anyone began performing the version of themselves they had prepared. What I noticed first was that when Eleanor and her daughter entered and took their seats, Derek Voss did not look at them. His eyes went to his attorney, then the table, then the window near the east wall. Not to Eleanor, not once that morning. That detail does not appear in any transcript. It appeared in me. I want to tell you one honest thing about Derek Voss because honesty about the people in these cases is part of what keeps the telling real. During a recess on the second day, I passed the side corridor and heard him on his phone. His voice was lower than it had been in the courtroom, and he was saying, "Dad, I'll call you tonight, I promise. How is she feeling today?" He was asking about someone who was sick. I don't know who, but I heard it and I thought, this man loves someone. He knows what it is to wait for news about a person who matters to him. And then I thought about Eleanor standing at the end of her driveway for 22 minutes in her slippers reading his letter. The fact that he loved someone did not make what he had done more forgivable. It made it less, because he knew what that kind of waiting felt like. He knew what a letter could do, and he signed it anyway. There were 3 moments in that courtroom where the room went completely quiet. Not the quiet between sentences, the kind that arrives when something true has just entered a room and no one yet knows what to do with it. I am going to tell you about all 3, but first, what happened between that driveway in April 2019 and that September morning 2 years later. After the April 14th denial, Dr. Okafor filed a first-level appeal on April 22nd, denied May 7th. A second-level appeal filed May 15th, denied June 3rd. Under Eleanor's policy, and this is something most people don't know, there is a rule called the exhaustion requirement for external review rights. Before a patient can take an insurance dispute to an independent outside reviewer, they must first exhaust every internal appeals pathway the company offers. The rule exists to give companies a chance to correct their mistakes. What it also does is add months that a person with a cancer diagnosis does not have to spare. Eleanor exhausted her internal appeals by July 19th. The external review board issued its findings on August 30th. The denial had been inappropriate. By then, Eleanor had found a charity program through a hospital foundation that covered her first chemotherapy cycle. She began treatment August 12th, 18 days before the review board confirmed what Dr. Okafor had known in April. By the time treatment started, the cancer had moved from stage 2 to stage 3. I want to be honest about one thing while I'm telling you this. I can rule. I can respond with everything the law permits. I cannot undo those 4 months and 16 days. I cannot give Eleanor back the stage 2 window. I knew that before the trial began, and I knew it every day on that bench. I'm saying it plainly rather than carrying it quietly. If something in what I have said so far has stayed in your chest, subscribe, because what I am about to tell you next will stay longer. Subscribe now, and then let me keep going. Eleanor walked into my courtroom at 9:07 on the morning of September 14th. She wore a dark blue cardigan and moved with the deliberateness of someone who has learned their body in a new and serious way. She sat down at the plaintiff's table, placed both hands flat on the surface, and looked straight ahead at the seal on the wall. I noticed her hands. They did not move. I've watched a lot of hands on that table over the years. Eleanor's were still in the way that requires effort, the kind of stillness that is a decision, not a condition. I had read every page of the file before the trial, the diagnosis, the authorization request, the denial, the appeals, each one worded more bureaucratically and more remote from Eleanor as a person than the one before. The oncologist's notes from August, written in clinical language that nonetheless described something irreversible. The financial records that showed Eleanor had sold a gold bracelet, a piece of jewelry given to her by her late husband, to pay for a blood panel Caritas had also denied in the same period. I knew all of it. What I did not know was how it would feel to hold that knowledge in a room where Eleanor was present. Those are different kinds of knowing. The first witness was Dr. Okafor. After about 40 minutes of testimony, Eleanor's attorney asked her to read aloud the reason for denial from the letter. Dr. Okafor read, "The requested treatment has not been demonstrated to meet the criteria for medical necessity as defined under Section 4.7b of the subscriber agreement." That was silence 1. Section 4.7b. Eleanor Marsh. Not medically necessary. The room went quiet in a way I can describe precisely. It was the silence of people absorbing the distance between language and truth. Not outrage. Something quieter. The court reporter's hands hovered above the keyboard, not typing. Eleanor's daughter in the gallery put her hand slowly over her mouth. Derek Voss looked at his attorney. The silence lasted about 8 seconds. It felt longer. Eleanor took the stand the following morning. When her attorney asked what she most wanted the court to understand, she was quiet for a moment. Then she said, "I just want someone to tell me that it mattered, that what they did to me mattered." She said it plainly, not for effect, the way you say something that is simply and completely true. I wrote it down on the pad in front of me. What I understood after silence 1, and after hearing Eleanor say those words, was the specific shape of what had been done to her. Not only the medical harm, which was documented, but the human harm of being told through the formal language of a subscriber agreement that your need did not qualify. I had read those words in the file. I thought I knew them. I did not know them the way I knew them after that morning. Subscribe. I will say it plainly. I owe it to Eleanor to keep telling this story. Subscribing is how her story reaches past this video. Subscribe and stay. Derek Voss took the stand on September 15th at 2:04 in the afternoon. He was composed, prepared, careful about the lane he stayed in. When asked about the criteria applied to Eleanor's case, he said, "We have protocols for a reason. My job is to apply the protocol, not to make exceptions." He said it with the even certainty of someone who believes that is a complete answer rather than the beginning of a larger question. When Eleanor's attorney asked whether he had personally consulted a physician before signing the denial, he said, "I don't recall reviewing that particular file personally." He said decisions of this kind went through a review team. He trusted the process. Then Eleanor's attorney asked him one final question. Given everything he now knew about what had happened to Eleanor Marsh in the months after the denial, what would he want her to understand about why that decision had been made? He paused. He looked at his hands on the witness railing. Then he said, "I understand this is difficult, but the system works the way it works, and my job is to protect the actuarial integrity of the plan." I wrote that sentence down. I looked at it for a long time before I moved to the next page, because in that sentence, Derek Voss told me something he did not intend to tell me. He used the word difficult. He acknowledged in that one word that something hard had happened to a human being. Then he placed the actuarial integrity of the plan beside her on the same scale and told me which one outweighed the other. He thought that sentence was going to demonstrate reasonableness. What it demonstrated was that he had understood the cost of his decision to Eleanor and made it anyway. Whatever remained of the defense after that moment, I was going to have to be shown. I was not shown. That was silence too. Not the silence one kind. This one was colder. Silence one had been absorption. This was arrival. The silence that settles when a proceeding has reached its actual destination before the procedural ending catches up. Derek Voss looked at the gallery when his attorney said no further questions, then at the seal, not at Eleanor, not that day either. "I want to tell you something that has nothing to do with this case, or rather everything, and I am not going to explain the connection. When I was 11 years old, my mother was in the hospital for 9 days. I'm not going to say why. What I remember is the telephone in our kitchen, a wall phone, yellow, with a stretched spiral cord, and my father standing next to it in the evenings, not waiting for it to ring, just standing close to it. There was a form he had submitted, a process he was waiting on. People on the other side of that process were applying their criteria, doing their jobs. My father stood next to the yellow telephone because it was the only version of doing something that was available to him. I thought about that telephone more than once during those 9 days of trial. I did not tell anyone in that courtroom. I am telling you now. If you are still here at this point, you already understand why I am telling this story. Subscribe. This is what I do now. I tell the cases that stayed with me. Subscribe and you will hear the rest of them. The defense case ran a day and a half. Patricia Curran, the defense attorney, competent and careful, argued that Caritas had followed its internal procedures correctly, the denial had been issued in good faith under the policy terms, and the progression of Eleanor's cancer could not legally be attributed to the denial because alternative treatment had been available. One moment gave me genuine pause. Curran introduced evidence that on the same day as the denial letter, Caritas had also sent Eleanor a letter offering access to a patient case manager who could help navigate appeals. Eleanor had not called the number. Curran argued this demonstrated good faith. I looked at that document and thought carefully about what it means to receive a rejection and an offer of help in the same mailbox on the same day, about the same decision that had already been made. I decided it did not change what the denial had cost, but I sat with it the full length of time it required. I'm about to tell you what I ordered. Subscribe before I do, not because it is dramatic, but because I want to explain every part of it, and I want you to be here for the explanation. Subscribe now. On September 22, 2021, I returned to the bench at 10:15 in the morning. I had written the ruling out by hand the night before, which is not my usual practice. I do it by hand when I need to feel the weight of each sentence before I speak it, when I need to know I mean every word individually. Eleanor sat down and placed her hands flat on the table. Derek Voss sat and folded his. I had made this decision carefully. I had made it knowing careful decisions and right decisions are not always the same thing, and believing that in this case they were. I found for the plaintiff on all 3 counts: bad faith denial, negligence, and intentional infliction of emotional distress. Eleanor's daughter took Eleanor's hand. Eleanor sat still. She nodded once, small downward. The room was quiet. That was silence 3 completed, and I had glimpsed the edge of it at the very start of this story, that hum in the ceiling, that settling weight. Now I was inside all of it. About 5 seconds of complete stillness. Then Eleanor's daughter said something I could not hear. Then someone in the gallery exhaled. Long, slow, the kind held without knowing. Then the room came back. I looked at Derek Voss. He was looking at the table. Now I want to tell you what I said. I am ordering you, Derek Voss, to pay $340,000 in compensatory and punitive damages to the Eleanor Marsh Cancer Recovery Fund, established through this court and administered by the County Hospital Foundation. This figure reflects the delayed treatment, the progression it enabled, and the extended monitoring Eleanor carries forward for the rest of her life. It is not a symbolic number. It is the number that looks directly at what was lost. I am ordering the suspension of your insurance adjudication license for 5 years, effective immediately. You will not review, deny, approve, or advise on any insurance claim during that period. Every person who submits a claim in those 5 years, every person who waits for an answer about whether they will receive care, none of them will be reached by your judgment. That is the point. I am ordering 500 hours of community service at St. Catherine's Cancer Treatment Center in this county, not in administration, in patient services, specifically the unit that helps patients navigate coverage denials and insurance appeals. You will sit across from people who are exactly where Eleanor was. That is not a punishment in the retributive sense. It is education. It is long overdue. I am ordering a written public apology of no fewer than 800 words, published in the State Insurance Regulatory Bulletin and delivered by you in your own voice at the State Insurance Regulatory Conference in the following calendar year. You will not send a representative. You will stand at that podium and speak the words you wrote to the colleagues and peers who share your profession in the industry whose protocols you told this court you were simply following. And I am ordering that Caritas Health Partners provide Eleanor Marsh with 10 years of comprehensive health coverage at no cost to her, with no prior authorization requirements for any treatment her oncologist recommends related to her ovarian cancer or any recurrence. She has already paid the cost this coverage was supposed to prevent her from paying. I will not ask her to pay it a second time. Then I spoke directly. Derek Voss, you denied Eleanor Marsh's chemotherapy authorization on April 14, 2019. In the 4 months and 16 days that followed, the cancer moved from stage 2 to stage 3. That is in the oncologist's notes and in the findings of the external review board. She sold a bracelet her husband gave her. She stood at the end of her driveway in her slippers, and she did not surrender. She found another way because she had no other choice. The fact that she found another way is not evidence that you left her a door. It is evidence of who she is. To your family, I will say only this. I am not here to speak to who you are in other rooms. That is not mine to say. You held a position that required you to look at a 72-year-old woman's cancer diagnosis and ask one question: does she need this treatment? That was the whole question. You answered it with Section 4.7b. The last thing I have to say does not belong to you. It belongs to Eleanor. You sat in this courtroom for 9 days and you put your hands on that table and you were present for every word. The kind of steadiness that requires not loud, not performed, simply showing up and remaining inside a process not designed with your dignity in mind, that kind is not small. I saw it. I want you to know it was seen. Thank you for staying with this. I mean it the specific way you mean something when it cost you something to say. Subscribe if you have not. You already know why you are still here. When the room began to empty, I stayed on the bench. Eleanor rose slowly, her daughter's arm around her. She stopped once at the end of the gallery row and said something brief to a woman I did not recognize. Quiet, unperformed, the way you speak when only the true part is left. The woman held Eleanor's arm for a moment. Then Eleanor walked out without looking back at the defense table. That absence, the not looking back, said more than most of what had been spoken aloud. When I finally stood, the room was nearly empty, and I noticed for the first time a fluorescent light in the second row flickering, a faint, irregular pulse. I had been in that room for 9 days and never seen it until the silence came back. Patricia Curran filed an appeal on October 8, 2021. The 7th District Appellate Court heard the case. On March 3, 2022, they upheld the ruling on all counts with one revision. The financial penalty was reduced from $340,000 to $280,000, as the original figure had exceeded the statutory cap for compensatory damages as applied to the emotional distress count. I read the ruling the morning it issued. It was not wrong, technically. It was the kind of technically correct decision that shows you exactly what the gap between law and justice looks like when measured carefully. On October 3rd, 2023, an envelope arrived at my chambers. No letter inside, just a photograph. Eleanor Marsh standing next to a young woman in a graduation gown, both of them squinting into afternoon sun, both of them smiling, the unguarded kind, the kind that isn't arranged for anyone. Eleanor's hand was on the young woman's back. I put the photograph at the corner of my desk where I keep the things I need to be able to see. It is still there. I have been thinking, since this case, about a question I cannot answer. What do we owe each other when the structure we are working inside tells us we owe nothing? Derek Voss did not break the protocol. He followed it, and the protocol was wrong. He had worked in that field for 11 years. He knew at some level that precedes paperwork that it was wrong. He signed the letter. So what does protocol protect when a person uses it to avoid knowing what they already know? I do not have an answer. I have kept asking. Grief and clarity are not opposites. In my experience, one tends to produce the other if you stay inside the grief long enough instead of walking around it. I have stayed inside this one. I am still there in some small way. If you have been where Eleanor was, if you have held a letter telling you that what you needed did not qualify, if you have spent energy you did not have proving that you deserved what you were simply owed, I want to speak to what I saw on her face during those 9 days. It was not defeat and it was not rage. It was the expression of someone who has been made to spend irreplaceable time proving a thing that should have required no proof. I have seen it before. I see it now. Whatever part of Eleanor's steadiness belongs to you, keep it. And if you have held a position like Derek Voss held, behind a protocol with a signature line, I want to ask you the question I could not ask him from the bench. Do you know the name of the last person whose claim you denied? Not the file number, the name. Do you know one true thing about their life outside the document? I am not asking to shame you. I am asking because I believe one name, held honestly, would change the decision. I think it costs something to stop asking that. I think the cost is worth paying. There are other people I want to speak for, other cases where someone came into that room needing more than procedure and received only procedure. Subscribe and I will tell you those stories when I am ready. This was the first one I was ready for. I started today with a name. I want to end there. Not the plaintiff, not the case number. The woman who stood at the end of a driveway in her slippers on April 17, 2019 and read a letter she should never have received, and who walked into my courtroom 2 years later and put her hands flat on that table and stayed for every word of it. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if this has stayed in you, leave something in the comments. I will read it. This is a room too, in its way. A room where people who care about the same things can find each other.